Hi, it's Lori Brown with YourNurseAttorney.com. I'm a registered nurse as well as an attorney, and today my special guest is Marc Lopez. Marc, welcome.
Thank you for having me.
Marc's also an attorney, and he does criminal law. And we have been getting so many questions about this Office of the Inspector General, and it seems like it's DUI day in Indianapolis and having a lot of clients with DUIs. So as you know, I'm always about preventing problems rather than having them occur. So we're going to talk a little bit today about how to prevent problems and what the OIG is and how to avoid getting on that list. So welcome, Marc.
Thank you for having me. I really appreciate being here.
You're so welcome. Now, we have a really funny story how we met. We are both in what's called the Trial Lawyers College study group or something, where we get together and we talk about our cases, and we don't just talk about them, but we try to figure out what the story's about. And I just go because I think it's a really cool group of people, and it's a lot of fun getting together and seeing how people put their cases together. But Marc's actually gone through the program. So Marc, would you like to talk a little bit about what the Trial Lawyers College is?
Absolutely. The Trial Lawyers College was founded by Jerry Spence, this national renowned attorney, and you can type in Jerry Spence YouTube videos and you just see this amazing trial lawyer. And I actually had a chance to spend an entire month in Wyoming, the mountains of Wyoming, no cell phone signal, no internet. You're basically just learning about trial practice, and one of the big things is connecting with the jury, putting yourself in your client's shoes. A lot of attorneys don't agree with that position, but to connect with the jury, you have to do that. And it was an absolutely life-changing decision for my practice, my professional relationships, my personal relationships. My wife said I came back a different person. It was one of the most amazing experiences I've ever had. And seeing Lori at these, try to do it every month, these little get-togethers, these workshops, has just taken my trial practice, and just, you have attorneys like Lori and other attorneys who just been doing this for so long, know what they're doing, to get their feedback on cases, just invaluable.
And Jerry Spence, he wears this leather jacket with these fringes, and since he learned this method, he has not lost a case, and he does these major criminal matters, and he's just incredible. And I love his technique because it puts the care back into law. And at Brown Law, we're all about putting the care back into law. We practice law like nursing, and it's nice to see other attorneys doing the same thing, really caring about their clients and just going to the mat and doing whatever it takes to help them. So I'm thrilled to have met Marc and being part of this group, and I've referred criminal cases to him, and he's done an outstanding job. So I'm thrilled that we're colleagues and we get to share some information with you today.
Making me blush over here.
So anyways, Marc, tell the audience a little bit about your practice and where you're located. I'm
located in Indianapolis, right downtown near the monument, and I practice across the entire state, concentrated mostly in central Indiana. About 90% of my practice is DUI defense, and we do other criminal matters as well. I have 2 associates, and I'm the boss, and so we do trials all together, and they come to me for trial stuff, but I do have associates that we delegate cases to. But I feel like I made a small success for myself by actually fighting back on cases, and I would lose cases, but I win a lot of cases too. And no matter what, winner or loser, I've tried exceptionally hard, and my clients have observed that, and they value that.
I think maybe this is a generalization, but in a lot of my cases, I see the nurses being afraid to go to trial on their cases because they're afraid they're going to lose and what effect it would have on their license, and maybe they could just buy their piece. But Marc's not like that. He looks for the wrinkle or the hole in their case, and then he just rips it open.
A big part of this, people are scared to go into trial, but there are things you can do before trial. So if things don't go the way you want it to go, the judge doesn't have as great of incentive to punish you. So there's a whole process to this, and going to trial is scary for everybody. Yeah. But I feel a lot of attorneys, a lot of people don't take their case to trial, and quite frankly, I feel like some people are getting the short end of the stick by not taking the case to trial.
Yeah, and I know with the nursing board too, it's really, you don't want to go before the nursing board if at all you could avoid it, but there's a lot of things that we do ahead of time, a lot of things that we put into place, mitigating factors, things like that, to show that this is like a one-time isolated event. This is not who you are as a person or as a nurse. And unfortunately, the board, where I practice anyways, tends to look at you as being a nurse 24/7. And while that is true to some extent, you know, if it doesn't affect your professionalism and care of patients, you know, it's kind of a fine line there. So anyways, how can healthcare professionals avoid getting a DUI? And I know obviously the first answer is don't drink, but you probably have some other tips for them.
Absolutely. I think the easiest thing is if you're going to go out, have a plan to get home. And quite frankly, with Uber, I'm amazed that I actually have a viable business. Planning ahead is one of the key things. A lot of my clients end up having some sort of celebratory drink after some sort of happy event in their life, and they didn't plan on getting home. They drove. Other individuals just, you know, celebrating something, but this got out of hand. But if you can have a plan to get home without having to drive, you are allowed to have a drink and drive a vehicle. You're not supposed to drive while intoxicated. And so a really easy rule of thumb is, you know, about 3 drinks, you're probably at that line, and you probably need to start getting a cab or an Uber or have a friend drive with you. Obviously, if you weigh very little, might be 1.5 drinks, but generally my rule of thumb is 3 drinks. What I see a lot of right now is people going to the beer festivals, craft festivals, getting these beers with these crazy alcohol percentages. Oh. They're only having 2 of them, but it's knocking them on their feet and it's getting them in trouble. So if you're drinking things you don't normally drink, you might want to even plan for less than what you normally would.
And always drink on a full stomach. Don't drink on an empty stomach, because that raises your blood alcohol tremendously.
Absolutely.
And isn't there some kind of a curve? How?
There's a absorption and then there's elimination curve, and it's very difficult. It's easy, like I just had a drink, I'm clearly on the absorption curve, but it's not as simple as that. And you will have a situation if you're on the elimination curve, you literally won't feel as intoxicated as if you're on the absorption curve. And you might even be passing field sobriety tests, but you actually, a bloat or breath will come above the legal limit. And typically those situations, people will stop drinking hours ago, or they're even driving home from the night before, and they're getting stopped 0.10, 0.15 even. What we're seeing though too is officers are making arrests when they don't know when somebody actually drove, but we got a call earlier, so earlier their BAC would have been X, and they're assuming they're on the absorption or elimination. There's all sorts of questionable math and science involved with this, and one of the absolute top toxicologists, Dr. Kurt Wagner, has even said extrapolation, trying to figure out someone's BAC at this time based on something over here, is worthless science. And he's #1 state witness for decades.
Huh. So if somebody's drinking like that, how do you know where they are on the curve? And can they refuse a breathalyzer? What are their rights?
Well, DUI is one of the few crimes that does not require intent. So the best example of that, you know, if someone gets in a fight in the street, they meant to hit somebody. With DUI, you don't have to prove there's any intent to drive drunk. So how would we know? And that's one of the things they make these arbitrary 0.08 limit. Here's the line in the sand. Most people wouldn't know, and quite frankly, if you're a seasoned drinker, you might perform better on field sobriety test 0.15 than someone who drinks once a month, has 2 drinks and they're 0.05. The refusal issue is very complicated. Indiana changed their laws in 2014 and then again 2015. And if you refuse the chemical test, you lose your license for 1 year. If you have a prior DUI, it's 2 years. Now, I'm talking just for the act of refusing. There's still a DUI suspension on top of that. So if you refuse and don't have any priors, your maximum license suspension is 2 years. If you refuse and you have priors, you're looking at a 3-year suspension, even if that prior was 10, 15, 20 years ago. Additionally, Indiana created specialized driving privileges, which, for lots of reasons, Indiana was very fair in regards to the driver's license compared to other states. And they tried to make it more fair, the specialized driving privilege, to drive while your case is pending or afterwards. Most judges require extremely high insurance, 100, 300, and also a device in your car. Judges can do what they want regarding that. but that SDP is specifically excluded for any type of refusal. I would hesitate to advise anybody to refuse a chemical test. You've impliedly consented to that when you got your driver's license. At the same time, though, if you're giving a choice by the officer and you don't really have a choice, you have to submit to all the tests they offer. If you do have a choice, I would always go with blood as opposed to a breath test. And if anybody can see the machines they use for the breath testing, ECIR2, this is the brand new machine they spent millions of dollars on. It looks like an old Apple computer from the 1980s. But this is their brand new technology, which is foolproof and the best you can buy, and it's ridiculous. If you have a choice, ask for blood. But again, you cannot refuse the breath and say, I'll only do blood, because that counts as refusal. And additionally, Indiana, about 2 years ago, a case out of Hamilton County, they lowered the bar for refusal so low, where a young girl, basically, officer took her shoulder and she kind of jerked away. That's a refusal.
Wow.
There's no explaining or anything like that. The refusal stuff is very complicated, and I would not advise someone to refuse a chemical test.
So are those breathalyzers accurate, even though they have the newest Apple computer type machine?
I just did a jury trial with their state expert, Dr. Sheila Arnold. She's the state toxicologist, and she, in her training materials, put about a 12% margin of error on the breath machine. So if you're 0.08, you would be underneath their limit, but she makes a point to say, well, we calibrate a little bit low, so the overestimation is okay. So in the same breath, they say it's not a very good machine, but we undercut it a little bit to give benefit of the doubt. I'll be very honest with you. Juries, when they see that number, it's very hard to overcome. You typically to bring in experts and whatnot. So the best way to beat a DUI is obviously plan ahead and try not to get one.
Yeah, I mean, we're lucky in this day and age that Uber is so readily available. And it's not like, I know I've had people years ago who couldn't get a cab and just wound up driving, but with Uber, Lyft, everything like that, you shouldn't have any trouble getting transportation. And it's just not worth it. Don't take the chance. So let's switch gears a little bit and talk about substance abuse and diversion, and if you're how to avoid that Office of the Inspector General list. So basically, the Office of the Inspector General list is designed if a nurse has been taking, or physician or whoever has been taking medications from the hospital and withholding services or treatments from a Medicare or Medicaid patient. The list is designed so that if you're on this list, you can't take care of any patient who receives federal funding. And that means you can't even work in that facility even if you don't take care of them. So nurses on this list, it's kind of like the worst thing that can happen, because even though you still have your license, you can't take care of any Medicare or Medicaid patients. So you're limited to going to cash-only practices or areas that don't take federal funding, cosmetic surgery if they don't take insurance, things like that, or holistic doctors. So it's really difficult to find a job, or it's just difficult. So how do you prevent getting on this list? Any suggestions, Mark?
Well, I think if you had a professional license, specifically a medical type professional license, to call someone who's experienced with that. I recommend Lori Brown, and what I've done in my practice is work with Attorney Brown to make sure that my clients, if they are considering pleading guilty, if they are being offered diversion, we work it out so they're not admitting guilt to anything that would put them on that list. And so diversions in Indiana basically admit there's probable cause. You admit the state would find you guilty if you went to trial, and there's a blank line, they write the charge in there. And so one of the things that we've done in the past is, if they're only charged with something that would get them excluded, we can actually add a charge, do a diversion on something that won't get them kicked off, and then have them dismiss the charge that would result in some sort of exclusion.
Okay.
Obviously, the exclusion would be a life-altering event. People can't work anymore. So even though there's a zeal to prosecute and a zeal to punish offenders, you typically are able to negotiate that with the deputy prosecutor.
Yeah, and judges are very understanding of healthcare providers, and usually so are the prosecutors, and they understand that you want to continue your profession. So there's two types of exclusion. There's the mandatory, which means the Office of the Inspector General does not have a choice but to put you on the list, and then there's the permissive. And so mandatory typically involves some kind of a felony, and then it's mandatory to go on the list. So even if you go to diversion, like Marc was saying, and agree to diversion of your charges for a year, and if you do well for a year, the charges get dismissed. And it sounds like a great option, right? You don't want that felony charge hanging on after that year. So, but unfortunately, that will get you on that list. So really the rule of thumb is any felony charge, forget it. Do a misdemeanor. And then you also want to make sure, to avoid the permissive category, that it's not a charge that is like theft or something that the government would think is withholding services from Medicare and Medicaid patients. So possession's okay. A misdemeanor possession's fine. You still might get investigated under the permissive statute, but it's a lot easier to argue that versus the mandatory. There's nothing we can do. The permissive, the easier it is. But if you're pleading guilty to theft, then even if it's a misdemeanor, you're still withholding medications from Medicare and Medicaid patients. So it's better to avoid that if possible. So do you have, so it sounds like it's pretty easy for the criminal law attorney to negotiate these things with the judge or the prosecutor?
Well, I wouldn't say it was easy, but what I would say is that the more you prepare for a trial, the more you're willing to put into a case. At some point, you're hoping the state of Indiana will say, what are we really trying to avoid here? And once you get to that level, when they know that you're ready for a trial, when they know that not only are you ready, you're actually willing to go through with a trial, you can typically try to negotiate alternative resolutions. And if something's mandatory, hey, we have to go to trial because we have to, unless you can do X, and they put the ball back in their court. And you have to be careful where you're coming from, because if the state knows exactly what you want, they're less apt to give it to you. So sometimes you have to be a little bit obtuse with your goals. And but the idea is always damage control, and I always prefer going to trial, but I can recognize if someone loses a trial and they can no longer work versus if they plead guilty or do diversion to a crime that is not mandatory or permissive. I could see how someone could be inclined to take that resolution as opposed to going to court. And so the proper foundation always is, though, preparing for trial. And that's how you typically get the results that you want.
So in your experience, how many criminal law attorneys know about this Office of the Inspector General list?
Honest to God, before I talked with you, Lori, I'm not even sure that I quite understood this. You and I have had past dealings, and I know that when you and I met, I started throwing these ideas past you, and you told me, hey, you cannot have X, Y, and D do this. But until you educated me on this, I had no idea. There's a well-known list of collateral consequences for truck drivers, people who are not citizens and whatnot. But, quite frankly, I would say the education to criminal attorneys is severely lacking, and something that you could lose your ability to earn a living and support your family.
And I wrote an article called Representing Healthcare Providers in Criminal Law Matters, and the consequences that can happen. So if an attorney needs that, feel free to have them contact me, and I'll be happy to share that. I know nothing about criminal law, but I've had too many clients that have wound up on this list inadvertently because their criminal lawyers just didn't know. And if I can help prevent that and help good healthcare providers keep their license, that's what I want to do, and keep them practicing, because it doesn't do you any good having a license and being on this list. So anything else you'd like to add, Marc?
If you have a professional license, it's best to get representation in criminal matter and your licensing matter early as possible. And then, even if you don't hire a lawyer or myself, you want people to work together to try to achieve the most optimal outcome for you. And it's so important. Sometimes, you get arrested, life doesn't just stop for you. You still have bills. You still have to do everything else you were doing before you got arrested. And it's sometimes easy to put your criminal case in the back burner, but that is the absolute wrong approach. And so reaching out is the very first step, and that's all I have.
Yeah, and go to somebody who has experience, whether it be before the licensing board or in criminal matters. Do your homework. Find out, what their level of experience is. How many jury trials have they had if it's a criminal matter? How many clients have they had before the board? Do your homework so that you can get the best representation possible, because your healthcare license does matter, and there's consequences on both ends of things. There was one other situation I wanted to mention. Unfortunately, sometimes nurses or other healthcare providers who have criminal matters pending, the board feels it's necessary that they don't work during the pendency of their hearing. So they ask for an emergency suspension because they feel that based on the criminal charges, they're a clear and immediate danger to the public. And not only that, sometimes if you do have felony charges pending, you can't work anyways because wherever you're working won't allow people to work with a felony charge as well. So part of the issue is, one that I just learned, because I don't do criminal law, is you supposedly have a right to a speedy hearing, but unfortunately that only means if you're in jail, right?
That's correct. So a speedy trial goes away. You have to bring you in trial within a certain period of time in the criminal rule 4, but the speedy trial you hear on TV and whatnot, that's if you're still in jail and either you can't afford bond or you've been denied some sort of bond. Typically you can't afford the bond.
Yeah. So again, if you want to keep practicing, talk to your attorney, tell them how important it is to get resolution to your matter so that you can go back to work in a timely manner. We've had nurses, unfortunately, who've been emergency suspended 1 year and 2 years. We had one who went to her trial and everything, she got a not guilty verdict, but yet she couldn't work for all that time and owed money to her criminal law attorney, her licensing attorney, everything, and wasn't having any income. So again, we're hoping that you're never in this situation. I don't think anybody wakes up in the morning and says, I'm going to get a DUI today, or I'm going to steal medication today, or whatever. Obviously, that's not what we wake up to do. But if you are in this situation, go get the help that you need and find a competent professional to help you. So, Marc, how can the people reach you if they need you?
You Google Marc Lopez, I'm the #1 hit. But
it's MARC.
it's Marc Lopez, 317-632-3642, mlopezlaw.com. Real complicated website there. But yeah, full staff, answer phone calls. We answer calls at crazy hours if there's an emergency, but don't call crazy hours if it's not an emergency.
I bet you get a lot of those.
I really do.
And again, you want somebody that the jury's really going to like, and I think, and who you're going to feel comfortable working with. So I wish you guys the best, and if we can help with anything, please let us know. YourNurseAttorney.com. Just tell us your story, or Marc's giving you his information as well. And we'd love to hear your comments below. So please write your comments in the comments box below. Thanks, everybody. Bye.
Thank you.